Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. The Honorable Supreme Court of India have declared that the trial court may decide the prayer of the defendant to file the written statement after setting aside the ex parte order under Order Order 9, Rule 13. This was stated by two judges bench, Justice M.R. Shah and Madam B.V. Nagaratna, while disposing the case of Sudhir Ranjan Patra, not Batra, Sudhir Ranjan Patra versus Himanshu Shekhar Srichandan in Civil Appeal number 3641 by 2022, dated 17/5/2022, just yesterday. You can see the citation in 2022 Live Law SC 492, page number 492. So please remember, here the Supreme Court held that where the ex parte order is set aside and the parties allowed to continue the trial, then it is for the trial court to decide whether to admit the written statement or not. Of course, ultimately the Supreme Court asked the court, they admitted the party to file the written statement. Ultimately, this is the result of this particular case. Right? So here, if you go to the facts of the case, please remember, of course, the defendants, they were already set aside, they were already declared as ex parte under Order 9, Rule 13. So they filed a petition under the same Order 9, Rule 13 to set aside the ex parte decree. So you may be knowing, as per Order 9, Rule 13, setting aside the decree which was given ex parte against the defendant. In any case in which a decree is passed ex parte, then the defendant may apply to the court which passed the decree. Maybe if he satisfies that, maybe on the grounds that the summons were not duly served, or he was prevented by any sufficient cause from appearing when the suit was posted on particular date. Maybe the bus was missed. So many reasons are there. Some bandh has taken place like that. Though the court shall make an order setting aside the decree against him. Please remember, if the decree is such that, it cannot be set aside, then it can't be done, right? So please remember, if there is no proper service of summons, that means summons were not served properly. If there is some cause which prevented him to attend the court on the particular day, his intention is to attend the court, but sometimes it happens. So if he is able to explain the court, it will be set ex parte. Now the point is whether his written statement, whether he is allowed to file the written statement at this particular point of time or not. This is the dispute here. So please remember, the trial court set aside the ex parte petition, allowed, but it did not allow the defendant to file the written statement. So he has to proceed with the trial, and at that time he can argue the matter. That's what the court said. Now, aggrieved by this, he approached the Honorable High Court. High Court also stated that the defendant cannot be permitted to file the written statement. So he can take part. High Court also said that he can take part in the trial without, propounding their own case. Now here, the defendant, he contended that once the suit is restored back to pavilion, when it is restored, definitely he has got every right to file the written statement. So they should have been ordered, their petition should have been allowed to file the written statement. So here the reliance was placed on Sangram Singh versus Election Tribunal. So in this case, please remember, on filing of the written statement, trial court can consider to allow the written statement. So ultimately, once again, the Honorable Supreme Court of India asked the trial court to consider the filing of written statement. As far this case is concerned, the appeal is allowed and the parties are allowed to file the written statement before the trial court, which will take a due decision or the necessary decision. So very good order. Normally we are under the impression that after setting aside the ex-parte order, no written statement, it will not be allowed. But here Supreme Court said when once the set aside order is given, that means that the suit is restored. When the suit is restored, the regular process should be followed. He should be given a chance to file the written statement. This is what the intention of the Supreme Court. So please read the interpretation correctly and enrich your legal knowledge. Thank you very much.